I'm Paul Brownstein. I'm an attorney here in Southampton, Bucks County, Pennsylvania, and my primary area of practice is family law, which includes all the usual kinds of things that lawyers handle when couples are not working out so well as they used to. Divorce, custody, support, and so forth. Today's topic I want to talk about a bit is a very important topic that usually comes up very quickly in every case, and that's support. In Pennsylvania, there are several kinds of support that can be awarded. One is child support, another is spousal support, as support for the other spouse. There's APL, alimony pendente lite, a type of spousal support, and then there's alimony proper, which is support that a spouse can get after a divorce has been granted. People are often surprised, in fact, when I tell them there was alimony in Pennsylvania, and there really is. And a little later on in my comments here, I'll address that point. For now, first, I want to talk about how support is calculated. What is it based on? Surprisingly enough to some people, it is not ordinarily based on needs or expenses, or I need the money because I'm short of cash. It's strictly, almost always based just on the relative incomes of the parties. If a person who is living or working apart from the other has greater needs because now they have a more expensive place to live in, have other expenses, and they say, therefore, I cannot afford to pay or I need more money, that will not normally be accepted or granted as an exception unless it is really, really extraordinary. And I won't be addressing that in today's talk. Basically, however, for working out what the income should be, it is a calculation of what is each party earning net income. Net income is a calculation of all of the income a person gets from any source, not just payroll for a W-2 employee, but it could include as well bonuses, commissions, extra special considerations, or even benefits of employment like a company car that you don't have to pay for. The value of that to you if you bought it is included in the figures as if it was support. You are allowed to deduct in calculating support anything that you have no choice with, obligations to pay, like taxes, Social Security, Medicare. You do not deduct things that are voluntary, like 401k and pension contributions, or even medical insurance that covers the other party. They're all looked at separately, but they add that right back in, on the theory being you're choosing not to get it even if you're not seeing it. And that sometimes gets people upset, because now they have an income calculation that's bigger than the money they're really seeing in their paycheck. They do this for both parties, husband and wife, or for that matter, parties who are mothers and fathers when it's child support, because the court doesn't require you to be getting divorced to get support, or even be married for that matter. You just have to be parents of a child, living apart, and that's the key. You must be living not under the same roof. There will not ordinarily be any support awarded to anybody if you're still living together. If you're living apart, then there's a right to get support, and it is never retroactive. If you wait around to ask for support, you will lose the right to collect all of that benefit until the day you finally file with the court saying, I'd like to have some. So people who are being nice and reasonable should understand there's a consequence if the other side turns out to be not so reasonable down the road. Similarly, when one asks for support, even if the other party doesn't know it yet, if that party is paying some money after it's being paid for, there you'll get the credit granted the other person because they paid it as and for support, if that's what it was. It doesn't include things like sneakers, taking the children to lunch, sporting activities and the like. They are invisible, literally, in calculating what support might be because of the way support is calculated. Basically, what the state does, it takes how much money does each person make net. I just described that. They add those two nets together. Now you have a combined amount. Every 2 or 3 years, there is an agency in Harrisburg that calculates what I call a market basket of goods and services. In other words, what would an average couple who earned that much combined income devote to the needs, however many children they may happen to have? If it's to yank up a number off the cuff, $5,000 a month combined net with 2 children, the state would say then the amount of basic needs on that amount of numbers is X dollars. To pretend that it's $1,000 a month, just so I can talk about it. And if the one who's paying support for child support is earning 60% of the combined income, then that person would pay child support at the rate of 60%, or in this instance, my hypothetical example, $600 a month. It is arithmetic. It is not based on individual personal needs of the parties. It's strictly an arithmetic calculation. It can be different if there's extraordinary needs. I said that. I won't deal with this here because that's not as common as people might think. And it's not because now I have a second household support. And surprisingly, also, not that now I have needs and expenses I have with a child from a different relationship. That is not counting. The court's attitude, though they look at those numbers, is you didn't have to go out and get a second family. You have an obligation, in this instance, to your children. They're yours too. So they calculate that number is, and these are called the Pennsylvania Support Guidelines. And based on that, they will issue an order, although you can always agree and not have to go to court. That's the wiser thing, since I hope in this talk it's obvious that if you get to court, they're going to do it this way. And therefore, to go to court and argue is a little bit unusual. The only time it may matter to go to court and argue is where one of the parties or both are not W-2 employees on payroll, when somebody's self-employed. When somebody's self-employed, then they're going to be calculating, by they I mean the state, what is it that you have as true money thrown off to you by your business. You know, your company has to have expenses, it has income, it has gross, it pays taxes, all of that, and what's left over is the net. And that net is then what your income is, and based on that number, they take off of that your taxes and Social Security. Keep in mind that just because the company is deducting expenses, they better be actual company expenses. Like the example of a car I mentioned a moment ago, if somebody owns their own company and the company's paying for their rent, their medical insurance, all kinds of things that ordinarily a person would pay for out of their own pocket, that all goes right to the bottom line of additional income. Often a big surprise. And when it's decided and done under Pennsylvania support guidelines almost universally, if you're not self-employed, the amount of money you pay in support is going to be by wage deduction or garnishment. If you're self-employed, they can't garnish your wages. Then you have to pay it direct. But by direct, I do not mean to the other parent. It's paid through the state in Harrisburg, and they remit. They won't accept a court order for support if you're paying direct. They want to be able to enforce it. And they can't enforce it easily if they don't know what's going on. That's essentially how child support works, and basically to sum it up, child support will continue until a child's emancipated. Emancipation under Pennsylvania law, since some years ago, when there was a Pennsylvania Supreme Court case, a well-known blue decision from the party's name, there is going to be a stop of support when a child's emancipated, and that is when a child is 18 years old or graduates from high school, whichever comes later. So if a child is left back for some reason for a year, it could be age 19. If the child is advanced by a year and graduates and then maybe goes and gets a job, it could be 17. 18 is the magic number. You're going to have a difficult time saying the child's emancipated if they quit school or left school at age 17, still living with one of their parents, not doing a whole lot, and say, see, he's not in school now, she's not in school now. It doesn't work that way. There are many, many more things about support to be worth talking about. This was a brief run through of child support. There's also spousal support. What a spouse, not the wife necessarily, it can be husbands too, mother or father, gets from the other spouse if they're earning less than the other spouse and still married. If you're not married, there's no spousal support. And that support will continue till you're divorced. And we'll deal with that another time. There's also alimony. That's money that a spouse can get after a divorce if there's a need for it. It's not automatic. And sometimes it's there and sometimes it's not. But surprisingly so, yes, there is alimony in Pennsylvania. And if you want to discuss this at any time, we're always available here. Our initial consultation on any topic, including this one, is no charge, as free as it can be, the best price. You want to call us at 215-364-1550, or you can even reach me by email, paul@lowerbucks.lawyer.com.